Good afternoon. I am Attorney Wilda Pomales. I am the family law attorney here at the Legacy Legal Team. Thank you, everyone, for joining us. I will be discussing today the equitable distribution changes that just occurred effective July 1st. So this month, and what Florida has done is amend its equitable distribution statute, Florida Statute 61.075, which governs the divisions of liability and assets when going through a divorce. And so, what these changes aim to do is to clarify and improve the process of dividing the assets and liabilities for the court to get that done. So, when you're going through a divorce, the court can determine before you reach that trial period or before you reach that final judgment, the court can determine and distribute what assets and liabilities get to be divided between the parties, between the spouses. And so the court can go ahead and get that division started before the end. And so in doing so, the statute, Florida Statute 61.075, give the courts the elements that it needs to review so that these divisions can take place. And so in clarifying, the court has to find good cause in making that distribution before the final judgment or before the trial. And so the court now in the revision of that statute, it now clarifies to state what is good cause, right? And so the changes start off by including now certain elements in which the court can determine what is good cause, what constitutes good cause. And so the courts must consider factors such as preventing the loss of important assets, covering dependent child-related expenses. And so sometimes because of the circumstances, just to address the loss of important assets, sometimes because of the circumstances, the parties are not able to pay their mortgage because now the houses are divided, the parties are living in separate households. And so before the property goes into foreclosure and the parties lose this asset, the court will allow the parties to determine, okay, are we going to sell it? Is someone going to refinance it? And are we able to divide it before we reach the end of our dissolution? And so that could be a scenario in which the court will enter an order determining what happens with that asset. Another factor is the child-related expenses. And so if we're needing to pay something for the children or one of the kids, the court can also use that as a determination factor. Another one is pay for divorce-related costs. And so sometimes we have parties where one of the parties is a stay-at-home parent and the other one is the breadwinner. And so by dividing the assets, we're allowing both parties to be on the same playing field and both of them to be able to get adequate representation and pay for those costs as needed. And so that way we can have more of a, maybe you can say, fair opportunity for each party to be able to litigate throughout the process. And then there are other relevant circumstances that justify that interim partial division of the assets. The other amendment or change that the statute has is with the marital and non-marital assets. And so the court has to classify what is a marital and what is not a marital asset and before dividing, and clarification in certain aspects like interspousal gifts of real property. They must meet the same criteria as real estate conveyance requirements. So meaning if one of the spouses is claiming that there was a gift done by the other spouse, there's this property. Let's just, for example, say that one of the spouses inherited a property and now the other spouse that is claiming that it was a gift within the marriage is just stating that it was a gift and now it needs to be divided equally or whatever the portions may be. The spouse has to show that there is a document that was executed. And the way you execute these documents when you're doing real estate conveyances is you have to have the witnesses present, you have to have the parties present, signing in front of a notary to execute this document. And so if all that is not done, then the court can determine that it's a non-marital asset at that time, as well as a spouse joining in the execution of a deed to convey homestead property to a third party does not alter the property's classification as non-marital. And so we have, again, these homes that may be inherited. And so just because the deed is changed and someone else, like an outside third party that is not a spouse, maybe a cousin, family member, friend, whatever it may be, if they get added onto that deed, it does not convert it to a marital asset that now needs to be divided as part of the dissolution. The other asset is closely held business interests. So marital interest in closely held businesses are now explicitly included as marital assets for valuing these interests. And so a lot of times that did not come in, or for whatever the reason may be, or was, but now the statute provides for that. Non-marital assets, the statute specifies that real property acquired by one spouse through non-interspousal gifts remains non-marital if not transferred to both parties as tenants by the entireties. And so the revisions are to ensure more consistent and equitable outcomes in a divorce. Again, these changes came about effective July 1st of this year. And anytime there are assets and liabilities, the court again has to start off with whether the asset or liability is marital or non-marital, and then determine from there how it needs to be divided. Of course, if it's a non-marital asset, then there's no division. The spouse that is entitled to that keeps it 100%. And then if it is a marital asset, what is that division going to look like? There's that presumption that the division is 50-50, unless you're requesting unequal distribution. And an unequal distribution meaning you're requesting a little bit more, the other party to receive a little less. And so what is it that you can show the court as to why that division needs to be unequal? There are different situations in which the court may grant an unequal distribution. Some of those issues could be the dissipation of one spouse of marital assets. And so we see this when we have consultations and one party comes in and says, I want to keep the house because there was infidelity. The infidelity unknown does not mean that there was dissipation of marital assets. And so we need to determine what those fees are or what those expenses are that may have been dissipated. And so it's a lot harder than one would think to prove that there were assets that were dissipated, because you would have to show, okay, what's more than just eating out and there's a receipt for a certain restaurant. What proof can we show that that restaurant meal was not the family going to the restaurant versus that spouse with the new partner, or whatever the case may be? And so it's very difficult. But again, we would have to determine after consulting, analyzing if we're retained for the dissolution, we would need to analyze the financial documents of both parties to determine what is there and what is not there. Another possible distribution that may happen is if you have minor children and it's in the best interest of the children to remain in the house, in the marital residence, until they graduate or obtain the age of 18. And so that's possible. It does not necessarily mean you guys have to sell the property immediately or move out immediately, but that all, again, needs to be going through the courts. If there is no agreement between the parties, then the judge would need to make that determination and rule on that. And then, of course, each party would need to present the evidence required to show that the court should rule one way or another. So a couple of changes just within that equitable distribution statute. Again, that statute is 61.075. And that is, again, to clarify, the statute has been used this whole entire time. It's just a few changes that were made to clarify and improve how those assets and liabilities are getting divided. We again, cannot give during our consultations, we are very limited with the information that we have. We can't give you certainty as to how something is going to be divided, right? We can't determine, okay, the judge, this is how the judge is going to rule. But once we're retained, we analyze again, financial statements, the documents that exist to be able to determine and build our case. If we can't reach an agreement, right? So it's always recommended that you retain an attorney, you retain representation to at least review what exists within the marriage to be able to determine how a resolution can be reached or possibly how you can prepare for an evidentiary hearing. We're always willing to help. You can seek us for certain representation. It doesn't have to be full representation. As we've mentioned before, we have the unbundled services in that we can represent you if you need representation just for a temporary hearing so that the court can determine if we can make those divisions of assets and liabilities before reaching that trial. We can represent you just for that hearing, and then you can continue on with the case as needed. So you can definitely call us for a consultation, for a limited representation, limited scope if it's just a consultation, and we'll be able to guide you. But definitely, it's advisable for you to reach out to an attorney to just see what your options are. And again, we've discussed the equitable distributions last month and what those assets and divisions are, what needs to be divided among the parties whenever the parties are going through a dissolution. But feel free to check out our blogs. We have some blogs on our website that may give you a little bit more information, or schedule an appointment and schedule a consultation with us so that we can be able to assist. Thank you.